This conference will now be recorded.
I think now you should be able to look at my screen, right?
Have we don't have an audience today. I don't know the reason why, but it's a relevant topic in that sense. I don't know why. Even for people who are not really involved in international tax, it's something which is worth as a concept which one must understand. So
These three people came and they left. I don't know why.
yeah, so they'll probably come back. I hope. Hmm. I have put up on the group also that we are about to start. Let's see. This is the biggest problem of study groups in all organizations, that unlike lecture meetings and all, study groups, you are never sure of what will be the commitment of people, and how many people will really join in. I think we have to follow the Bhagavad Gita path and say that. So we do our bit, and if for nothing else, it at least helps us to explain ourselves and present and formulate our thoughts. Audience is there, good. If it's not there, well, we really can't do anything much about it.
Yeah, absolutely no problem, sir. We can wait till whatever time and then we can get started.
We'll wait. So we'll wait 5 minutes more, Satyamurthy.
Sure.
Let's wait 5 minutes more. Otherwise, then we can start off because I think at least we will surely want to hear you. So
No, absolutely no problem, sir.
Mr. Satyamurthy, where are you based? Which city?
Chennai, sir.
Chennai. Okay. How's the situation there now? Back to normal or?
Yeah, we are almost back to normal, sir.
Okay.
Just few IT companies, they are still giving an option to work from home, or they operate with part of their employees from home and part of them from office. Except for that,
Okay.
almost everybody is resumed to office on full-fledged basis. Particularly Chennai being a manufacturing hub, the option of working from home is also very limited from their perspective. That is
Correct.
also
Correct. True. No, so
it's not
also a
like
lot of organizations which around till even 6 months back were thinking that they will permanently be on the hybrid model and all of that. Now
yeah,
that things have opened up, have all changed their view and gone back to completely physical mode.
true, sir.
So, I
I
think
think after a period of time, it doesn't work well when people work on from remote location and all.
true.
On exceptional need basis for health reason or something, probably it
Huh.
should work. But as a norm, I think it's difficult to get into that way.
So we also at senior at CA level, we are getting those requests from people saying that please allow us to work from home at least 1 or 2 days of the week, because it saves a lot of travel time. And now
Uh,
they are used to this whole concept and system, so
yeah.
they want to do it that way. So
True. Considering the nature of the work that we do, it's very difficult to handle everything from remote unless
yes,
everybody is experienced, everybody can handle things on their own actually.
true, true,
With
true.
articles, with very fresh people and all that, it's even in their own benefit, it's better for them to work based out of office.
Yeah, yeah,
And with, be it from the perspective of knowledge sharing, sharing the experience, experimenting with the portal or anything, I think the best thing is to work from office only.
true. So I think let's start it off. I think whoever will join in a while.
Sure,
So
sure.
yeah. So good evening to everyone who's here, and we hope we'll have some more audience in a short while. So this is the last session of the study group for this year, because the WIRC, the change of guard happens towards the end of February, and so we'll look at what is really going to come up on the group going forward. But this is going to be the last presentation for this year. So thank you, Mr. Satyamurthy, for volunteering and actually coming across to present this topic, which is actually a very contemporary topic, and it's actually good that somebody is going to be speaking on a absolutely contemporary subject, and within a few days of the circular, and within a few days of a path-breaking judgment as well. I think a very exciting thing to learn, and for once we saw the judiciary acting almost as fast as the bureaucracy was acting as well. So I think it was interesting. So Mr. Satyamurthy, as he mentioned, is from Chennai. He is a chartered accountant, has 8 years plus experience. He focuses on direct and international tax both, the entire spectrum. So that is advisory, compliance, assessment, litigation as well as he has experience in the audit and the assurance sector. Uh, he has worked with Deloitte for more than 4 years and has also been on the tax team of Pfizer for around 3 years in the past. So surely somebody who comes with a lot of practical experience and bandwidth. And I think it's going to be an interesting evening to touch upon the whole MFN subject. And he's got some interesting stuff lined up. So thank you, Mr. Satyamurthy, once again, and over to you. All the best.
Yeah, thank you very much for the opportunity granted to me to gather the literature and judiciary around MFN class and share a couple of my thoughts which I wanted to share. A very good evening to all of you. I will just get started. Today, the agenda of our discussion that has been planned is that we will we'll do a quick recap on tax treaties and MFN class. Then we will go through the Delhi High Court ruling in concentric services and few aspects which we feel has not been covered in the particular judgment. Then a CBDT circular that was issued on the same topic, and immediately it was backed by a Pune ITAT ruling as Mr. Apurva shared a minute ago. We'll just go through. These are the topics that I have planned to share for the day. We'll get started. Yeah. The thing is that now that recently we switched from the DDT regime to the to the system of classic taxation of dividend, all of us had to relook at the aspect covering treaties, aspects concerning dividend in the treaties. All these days, DDT was not covered under the treaty, so we never looked at treaty for dividend assets. Now that we have gone back to the system of classical taxation of taxing the dividend in the hands of shareholders, it necessitated us to take a fresh look into the aspects relating to treaty for taxing dividends. So that is the major reason why this has come up now as a hot topic in these days. So that way, people had a look into treaties. They looked at the MFN class that are available in each of the treaties. They took certain interpretation of those MFN class and arrived at a lower tax rate. and they went to the tax authorities requesting for a certificate, lower deduction certificate under section 197, claiming their tax rate that they wanted. As usual, the department objected to it, and they gave the tax rate without considering the MFN class. They said the assessee are not eligible to invoke MFN class in this particular case, and it was rejected. Then the certificate issued under section 195, 197 for lower deduction is not an appealable order as such. So the assessee went to High Court invoking the jurisdiction under writ petition. So this was ruled by. So the case went to Delhi High Court, and Delhi High Court made a detailed judgment in the case of concentric services. But immediately after that, couple of other cases also came to Delhi High Court. One was Nestle SA, and other case also came up. In those cases, they just followed the concentric services case. Once the Delhi High Court ruled in favor of the assessee, now department had to issue certain clarifications on clarifying its position, because Delhi High Court had considered the decree issued by the treaty partner, which is not a bilateral assess, which is a unilateral treaty issued by it, and they had considered it. But whereas there was no equivalent literature from India side assets, so just to make the position of India clear on this, and to communicate the India's position to all taxpayers, to the subordinate assessing officers and all that, this circular was issued. Immediately after the budget session went over, just in a day or two, this particular circular came. Then within a week's time, Pune ITAT ruling came, which dealt with certain important aspects in the circular, which was actually a very pain point, which was perceived as a pain point from the circular. So we will get into the details now. This is the chronology of the events, why this topic is being talked now. Yeah. Now what I will do is I will just spend a few minutes discussing what MFN class is all about. For a minute, I will forget the tax treaty itself, and I will just go to MFN class without considering into tax treaty. Say for example, about 20 years back, a particular area called Sriperumbudur in Tamil Nadu was chosen to be developed as an industrial belt in Tamil Nadu. So what the government arranged for a huge patch of land and all that. Then they invited all the investors to come over there, put up their factories, invest in Tamil Nadu and all that. In this background, one of the very finest automotive manufacturer who came to the Sriperumbudur area first, they requested that they will need some certain list of say government grant support from the government and all that. Government was ready to offer some of those. Government was not able to offer some of those requests from the company, from the investor assets. So what they had done is that they had inserted a clause in the agreement. The memorandum of understanding was entered into with the government, and they had inserted a clause in the government which basically said that I am the first one who is coming to this area to open an industry. In future, there could be many other people who are going to come here, because since this area is planned to be developed as an industrial hub. If you happen to offer a favorable position, if you are going to offer some more benefits to the people who are going to come after my agreement is signed, then you should offer all the benefits that you are offering to someone else to me as well. This class was inserted in their MOU, and it got signed. So by doing that, what they have done is they have safeguarded that their interest is taken care. There could be a lot of events that come in the future about which we are not aware. Which there could be a policy change by the government. A new government itself could come, and due to various reasons, there are always possibilities that something more could be offered to somebody else in future. So how do I ensure that I don't lose such benefits? That's why they had inserted this clause in the MOU, and went ahead with it. Now coming to tax treaties, although we are all very familiar with tax treaties, just to for the sake of completeness and give an introduction to it, the tax treaties is basically whenever a transaction is happening cross border, the cross border involving multiple jurisdictions, each of the jurisdictions try to tax the amount that is tax the income that is being earned out of the transaction. Say, for example, let me assume that a transaction, an audit firm in India, it is rendering some service to other countries, say, for example, US. Now, what will happen is this audit firm is the resident of India. So, as a resident country, India will try to tax it. Whereas the income is emanating out of US, income is arising out of US. So, US would say it is an income for which source is the US, so I will also tax it. They may say it. So that be the case. What happens is same amount get taxed in multiple jurisdictions, and when as an audit firm or as a person, for me it's a very difficult because I have to pay tax in two jurisdictions. To avoid these kind of things, these treaties were entered into. When these treaties are entered into, it basically provides an allocation rights. It says this particular jurisdiction will get so much of share in tax. This other jurisdiction will get so much of thing. For example, again in the same example that we discussed, the US will say I will tax so much in so based on source and fix up a percentage or fix up something things. So this is limit. They will limit their taxability, and then India what will do is India will give a credit. One of the ways in which double taxation is reduced predominantly is through giving credit. India will give a credit for tax paid under US. So my net tax outflow will be still is what I would have paid if I had to pay tax in only in one jurisdiction. This is the whole concept about the tax treaty. So what happens in tax treaty is that today I may enter into a tax treaty with the country and I may say wherever I am charging tax on source basis, say for example, I will say I will charge it at a 15%. I will prescribe certain thresholds, certain tax rates, certain limits, certain limitations on deductions and all that. Again, as we discussed in the previous example, same way, they don't know what I could agree with some other countries in future. What if I give more than this? What if I just say it's just 10% for with some other country? They will also, but they don't want to get jeopardized of that benefit which I may be giving to somebody else in future. So they want to have a class MFN class in their respective treaties to say that, look, if you give it to somebody else, then you will have to extend the same benefits to me as well. Sometimes in certain treaties, it is open-ended saying if you give the benefits to any country, that same should be applied to me as well. In certain other cases, it is like if you give it to a certain class of companies to which you are giving benefit, then this class will get triggered. For example, many of the treaties has such criteria as a OECD member. If you give certain rights to other certain concession, certain benefit to some other OECD member, then the same should be extended to me. The school of thought or the logic behind is what that once you say a country has obtained membership, OECD membership, they felt that they are all on the same economic scale. Say they are all developed countries or they are all developing countries, something like that. They fall into the same bucket of same bucket, and they wanted that they should be equal. They should be treated equally. They did not want any inconsistencies between them as such. So to safeguard such their respective interests, they ensured that MFN class is inserted. MFN class guarantees recourse against the discrimination which could come up in the future. Typically, MFN class is given for 2-3 things like if you offer a lesser tax rate, then the same should be applied for me as well. If the scope of your taxation is lesser, say for example, you don't charge capital gains tax at all, then it is the scope of taxation is lesser. That be the case, again, that will also be extended. In some cases, some thresholds or conditions prescribed for claiming certain deduction, treating something as a permanent establishment, and all those things. These are the major things where MFN class is actually It is okay. MFN class actually operates in this arena, basically. Yeah. To understand how practically an MFN class operates through a particular transaction, it would be helpful if we can take up an example and try to apply the tax provision to that. That could be, I feel that could be the easiest way to understand the impact of the MFN class. So now let me take up an example. Let me take, that is an Indian company. This Indian company is into manufacturing. It has certain sophisticated machineries, plant and machineries in place. It is very advanced and it is taken care of. It is operated through softwares. Where it is operated through, where it is operated through softwares, where they feel that the machinery is not producing the intended results, or it is not functioning in the way in which it has to function, where they feel so, they need to get some assistance to set it right or to do some repairs or something like that. The costs for such non-operating of the plant or the software should be investigated, and resolution for that too should be made. So in this example, assuming that they are engaging a service provider who is based out of France for this purpose, now let's try to analyze the tax implications in this circumstance. Yeah, under the first, we will analyze the tax implications under the Income Tax Act. When I look at from the perspective of Income Tax Act, Section 917, it deems any fee for technical services paid by an Indian company or Indian concern to be an income of all the, irrespective of whether it is a resident, non-resident, or irrespective of whether the recipient is resident or non-resident. And fee for technical service is defined in the explanation 2 to the said subsection. It is, if you look at the crux of the definition, it says that any managerial, technical, or consultancy services fall within the ambit of FTS. In this example that we saw, this tweak to the machinery, that finding out the cost for deviation, tweak to the machinery, repair of all these are definitely technical in nature. So without any doubt, it will fall under the ambit of fee for technical services. Once I say that it will fall under the ambit of fee for technical services, then we should have to see what is the tax rate at which it has to be taxed. Section 115A provides that the FTS will be charged at 10%. This is the tax implication under the Act as such. Now we can move on to tax implications as per treaty as well. Section 91 of the Act provides that it empowers the central government to enter into treaties with various countries. Section 92 provides that with the beneficial provisions, either the treaty or the Act, whichever is beneficial to the assessee shall apply. Apart from 92, this particular interpretation that whichever is beneficial will only be applicable has been confirmed by the Supreme Court in various cases, say Kulandagan Chettiar, Azadi Bachao Andolan, and all that. Subsequently, CBDT had also issued a circular clarifying that only the beneficial provision should apply, because certain tax authorities, they try to tax the amount, they try to apply the provisions of unfavorable provisions of the treaty and all that. So this particular circular was issued to avoid such interpretations. So it is a well settled principle now. So now having said that, now we will have to go back to treaty and see what is the taxability as per the treaty. Hence, now we proceed to look at the provisions of the treaty. Yeah, look at the provisions of the treaty. I will just give you a minute to read the provisions of the treaty with regard to taxation of fee for technical services.
Sir, can you change the slides or somebody needs to do it?
I'm changing the slide.
Ah,
You are able to see the screen that is with India France TTA, right?
we can see the earlier screen only, the one on recap tax treaties and MFN clause.
This section, this starts with section 90, subsection 1. This slide,
Yes,
which
yes.
I'm.
This one we can see. Yeah, we can see this.
Yeah. Just I have just given the extract from India France DTA, which is Article 13. If we look at India France DTA, it says that the source country shall the source country can also charge the FTS to tax, but the tax rate should not be more than 10%. That's what the article says. And the fee for technical services have been defined in the same article. The definition provided is more or less similar to the definition as per our domestic income tax act. If you see again the managerial, technical, consultancy nature, the services of this nature have been defined as FTS. So if we look at the treaty and the act, really we hardly get any benefits out of this. Only thing is, if we go under the act and under section 115A, we will have to compute tax at 10%, then add surcharge and cess to it. Whereas if you go by treaty, the rate 10% given in the treaty is final rate, and there is no surcharge or cess to be added to it. So the beneficial is obviously this, but the benefit doesn't appear that huge. The benefit appears to be a very narrow one. But now we can, as far as treaty is concerned, we can never stop with the respective article. We will have to go through the treaty in entirety before we could finalize the rate as per treaty. So now we should proceed to see whether there is anything else in the preamble or protocol, something like it in the treaty. So we proceed to look at the protocol given in the India-France DTA. Again, I will give you a couple of minutes for you just to go through the provisions relating to this contained in the protocol. I hope you are able to see the protocol now. Yeah, may I proceed? I hope you would have completed reading the protocol. I will proceed. Yeah. So now the protocol provides that the very first statement in the protocol is that the protocol says it is also part of the treaty itself. It is an integral part of the convention. That means it is also part of the treaty. That is the first statement that it makes. Then there are various clauses given in the protocol. The one that is relevant for our discussion on FTS is class 7 in the protocol. So I just directly jump to class 7. Yeah, if we look at class 7, it says that in case India enters into a treaty with another member of OECD after a specific date, which is 1/9/1989 in this case, probably they would have negotiated this particular treaty in 89. That's why they are saying if you enter into any treaty after this, if at all you do it, and if you give a lower rate of tax or a restricted scope, if you give a lower than this, or a scope which is restricted, or scope of income which is subject to tax, if that is restricted than this India France treaty, then such provisions of treaty where the lower rate was provided or restricted scope was provided, that should be that should be considered for India-France treaty as well. This is what the nutshell explanation for this particular MFM class. So with this understanding, so now our job is to go and find out to find out whether India has entered into a treaty with some other OECD member where it has given a lower rate or a restricted scope, so that we can take the benefit of such treaty here. In our search, we find that India has entered into a treaty with USA, and India USA treaty has been notified on 20 December 1990, which means that the condition given that it should be after 1st September 1989 is satisfied. So if the scope is restricted, we can take the benefit of this particular DTA. With this understanding, let's try to understand the article relating to taxation of FTS in India-US treaty. I will just give you a minute's time to go through this Article 12 of India-US treaty, which talks about FTS. Yeah, I think I can proceed now. Please stop me whenever you want me to stop. If you have anything to discuss now, please feel free to stop me then and there. Yeah. Now, when we look at USA, India-US DTA, the rate given is 15%, the exact of which I have not included since it is not anyway lesser. But if we look at the scope of what is considered as a FTS, we see this particular definition. It says any technical service or consultancy service is considered to be FTS only if such services are in some way related to royalty. That's what it's class A it talks about. If it is in some way connected to royalty paid for intangibles or equipment, then it will fall under the definition of FTS. Otherwise, in case it makes any technical knowledge, experience, skill, know-how, or process, technical plan, etc., if it makes available these things to the recipient, then it should be considered as FTS. So the definition of FTS that we saw in Act and France Treaty, it just said if it is a professional, technical, or similar nature, whereas this particular definition is totally different. Now let's try to understand the difference, the impact of the difference through an example. Say for example, I am rendering an audit service to a particular company. Assume if I were to evaluate under the erstwhile definition under France Treaty, it is a professional service, so it is an FTS. Whereas if I were to see at this, am I making any technical knowledge, skill, know-how, or something available to my client? No, I'm not available. I'm not making anything available to him as such. So it will not be considered as an FTS. Whereas consider an example of where in providing a training on taxation or training on some IFRS, Index, or something like that. Then it makes them available a technical knowledge. It makes some skill available for them. That be the case, it will be considered as FTS under US treaty as well. This is the major difference between the scope of FTS provided in France treaty versus the scope provided in US treaty. Assume so the scope provided in US treaty is comparatively lesser than that. So if I can import this into my France treaty and say the service of repairs to machinery, tweaks to machinery that we discussed in our earlier example, that definitely doesn't make anything available to the client. It only gives it just makes the machinery to run properly. That's all. Otherwise, it is not giving any technical knowledge, experience, or anything. That guy will not be able to solve the issue on its own next time. If he has the issue next time, he has to again call me. So definitely, I'm not making any technical knowledge or anything available to him as such. So that particular service will not come under the ambit of fee for technical services. So I can say it is not taxable as FTS. So this is the impact of importing uh, the restricted scope into the treaty using MFN. Say till this juncture, am I being understood till this juncture? Do you have any questions till this, please?
I think we are good. We are good.
Yeah, okay. Then I will proceed. This particular, so this particular operation of MFN class, even without this particular operation of a MFN class and protocol has been confirmed by plethora of judgments. I'm just quoting few of these judgments just to get a feel of what is the view of judiciary on this. Say, for example, in Karnataka High Court held that if the DTAA provisions read with protocol is favorable, then that will override the provisions of Income Tax Act. So the benefit has to be provided. Similarly, Mumbai Tribunal has held that India US Treaty or India Portuguese Treaty, where the scope of FTAs is lesser than India France Treaty, then this can be read into India France Treaty. Similarly, Delhi High Court has made an important observation that protocol specifically states that it is an indispensable and integral part of the treaty itself. So the binding force on the protocol is as same as the binding force on the main classes also. So there is no distinction as such. So the moment we say that the treaty partners are bound to provide the benefit as per treaty, then they are bound to give the benefit of this protocol and MFN class as well. This has been confirmed in plethora of judgments, and there is no doubt, no ambiguity or doubt on this till now. Now that we have got a feel of what MFN class is all about, we are good to enter the controversy that came in the case of concentrics before Delhi High Court. So now I proceed to discuss the facts of the case in concentrics. As I told you before, this is about dividend, as we have moved to the classical taxation in classical taxation of charging dividend to tax. Again, I just give you a couple of minutes for you to go through here the tax rate given in Article 10(2) is that it is 10% for the source country. So, for example, in this example, or in the facts of concentric rule, what happened is holding company is in Netherlands. Such holding company holds over 99% of shareholding in the subsidiary in India, and the subsidiary in India is paying dividend to the holding company. Now we are analyzing the tax implications of this dividend in the hands of holding company in Netherlands. When we proceed to do that, as usual, we will first evaluate what is the treatment as per our Income Tax Act. Income Tax Act, we should refer Section 195 read with the Finance Act, or Section 196D, which will give a tax rate of 20% for dividend. And again, we go to look at the provisions of India Netherlands Treaty. Article 10(2) of India Netherlands Treaty gives that the tax rate should not be more than 10%. So without getting into protocol, the tax rate should be applicable for this should be 10%. But as we discussed, we should also look into the protocol of the treaty, and I have just given the extract of protocol to this treaty. I'll just give you a couple of minutes for you to read this protocol. Please read it carefully, as we will be seeing how this is being interpreted by the department, how it is being interpreted by the High Court and all that. Please take a couple of minutes to read this. Can I proceed?
Yes, sir.
Yeah. Again, as in the earlier treaty, here also they have said that if India is going to enter into a treaty with any other OECD member after the date of this particular agreement, where the rate is lower or scope is more restricted, then the provision of that agreement where it is the rate is lower or scope should be applied to this treaty as well. I mean to India and Netherlands treaty as well. This is what we get from reading of the protocol. But here, one more important fact that is to be noted is, one more important fact that is to be noted. Then we proceed to search whether India has entered into treaty with any other OECD members with lower rate or scope. In our process, we find that in case of Slovenia, Lithuania, and Colombia, the tax rate is 5%. And 5% in case of Slovenia and Lithuania, there is a condition prescribed. If the shareholder is beneficiary is a company and the company is holding more than 10%, then rate of 5% is applicable. Otherwise, the rate will be 15%. Whereas in Colombia, no such conditions have been imposed. So straight away to all the shareholders, it is 5%. Then the other important fact that is to be noted is that these treaties with Slovenia, Lithuania, and Colombia have been entered to in 2005, 2012, and 2014 respectively. Whereas these countries became a member of OECD only in 2010, 2018, and 2020 respectively. In all these cases, one thing that we notice is that when the treaty was entered into, they were not an OECD member. They became OECD member only subsequent to when the treaty was entered with them by India. This is an important fact that has to be noted. And having noted this fact, let's just revisit this this protocol that we read just a few minutes back. This protocol provides that if India enters into a treaty with another OECD member after the date of this agreement, the wordings that have been used is that if after the signature of the convention, under any convention or treaty, India and a third member which is a member of OECD, if India limits its rights to tax with lesser scope or lesser rate, then this will be applicable. So the very crucial word here is a member of OECD. The whole controversy is all about what is the relevant date on which I should be an OECD member. Should I be an OECD member on the date in which I enter into treaty, or if I enter into treaty and then subsequently I become OECD member, still I can avail the benefit of this particular protocol. That is the crux of the discussion in the case of concentrics. We'll just go through the arguments of the assessee, the department, and the observations and ruling of the Delhi High Court. Yeah, as I just discussed, India's position is the assessee argued that tax rate of 5% as given in the Slovenia, Lithuania, and Colombia should be applied to them as well. They said that the India-Netherlands treaty reads as this forms an integral part of the convention. So there is no more requirement that has to be satisfied. It just has to satisfy that there has to be an agreement with an OECD member. That's all. So the trigger of this MFN class will happen automatically, and there is no need of notification or something as argued by the department. Whereas department argued, first thing is that in order to be eligible for invoking this MFN, you have to be a member of an OECD at the time of execution of treaty and at the date on which you are trying to determine the taxability of the amount. On both these dates, you have to be a member of OECD. Only then you can apply the protocol. This is the first contention of the department. Second contention is that the department also said that there is the automatic trigger of protocol or MFN class doesn't arise. We have to notify saying this particular protocol is applicable for this particular country, and only then after our notification this is applicable. In case of the Netherlands, there is no such notification at all. Whereas they also highlighted that India-Netherlands treaty has been renegotiated and few amendments have been made in the treaty multiple times. Whereas in any of the amendments, they have not extended the tax rate of 10% to tax rate of 5% to in the India-Netherlands treaty, which also goes to prove that they never had an intention to extend the benefit of 5% to India-Netherlands treaty. These are the arguments of the tax authorities as such. Now we'll proceed to look at the ruling of the observation and ruling of the Delhi High Court. Delhi High Court said there is the need for separate notification doesn't arise. The moment the India and third OECD member has a favorable agreement, then such thing will be automatically should be extended to India and Netherlands. They relied on the ruling of Delhi High Court divisional bench in the case of Styria India, in where they had confirmed that there is no notification required subsequently. One thing that we should bear in mind in this is that the Styria India case is now pending before Supreme Court as department has filed an appeal against it. We will leave it apart and time being we will consider this income. Then they have also looked into class vocal commentary to say that the text of the protocol and the treaty they have an equal say and they have equal binding force. There is no discrimination or there is no preference over one as compared to the other. Then they have also gone into interpretation of the word is. They have told that considering the rules and all that, the is should be interpreted as such as if we are going to apply the treaty on the date of when we are going to apply the treaty, and the need that the third country should have been an OECD member on the date on which the agreement was entered into is not there. Then they have also looked into the decree issued by Kingdom of Netherlands. Decree is like an internal order, notification, circular, something like that. Netherlands had issued a decree, internal decree, which had told that subsequent as this MFN class has been by virtue of the MFN class, the rate in this Slovenia, Lithuania, and Colombia treaty should be read into Netherlands treaty, and 5% should be applicable for them. One of the principles in interpretation is that principles of common interpretation. According to principles of common interpretation, where two parties of the same out of two parties of the same agreement, where one interprets the provision as one, then the other also has to be the same and it cannot be different. Based on this interpretation, duly considering the decree issued by Kingdom of Netherlands, they favor this saying that the 5% should be extended even to India and Netherlands treaty. Further, they have also looked at the observations made by the Supreme Court in the case of Azadi Bachao Andolan, where the Supreme Court had told that the language in treaty is different. When you proceed to interpret the treaty, the principles which apply for interpretation of a law should not be the same, because the law is drafted by a parliament or legislator, whereas the treaty is negotiated by political side, or it is negotiated by diplomats. So generally the way we interpret treaty is much different, and it should be on the broad principles of general acceptance. It should be both the lawyer and layman should be able to derive the same meaning out of the treaty. Then further the negotiation of treaty is not a function of tax alone. It is a function of a diplomat which considers various factors like the relationship between two countries in terms of the volume of trade happening and all that. Many other factors are also considered when we enter into treaty. Not that only tax treaty is there. Diplomats enter into many treaties, right? So tax treaty is just one of them. So they would have done a bargain in one treaty. They would have given up in another treaty, and all these things can happen in treaty, which is unlike law. So considering all that, whenever we interpret treaty, we should consider all these. Was the observation of Supreme Court in Azadi Bachao Andolan, which has been highlighted by the Delhi High Court, and they held that based on a plain reading and based on these principles, the tax rate of 5% should be granted to Netherlands as well. There are a couple of aspects which appears that has not been documented in the said ruling, which is very vital. Probably tomorrow, if this case is going to be heard by some other high court, or if the department appeals to Supreme Court, these factors could come up. We will just go through these factors as well. One of the moment somebody talks about tax treaties, one of the very first thing that comes to our mind are a very first class. What an international tax person learns in his very first class is Vienna Law of Convention. The Vienna Law of Convention is nothing but a treaty which have been entered into between certain countries. This treaty was entered into in 1969, and so there are about 119 or 120 countries which are subscribers to this Vienna Convention. This convention is binding on them, whereas it is not binding on the others. But still, it provides a lot of rules for interpretation of tax treaties. So even although it is not binding on India, Supreme Court has referred to this Vienna Law Convention law many times in its judgment. For example, in Ramjet Malani case, Supreme Court had referred to this. So now it's vital to look into the rules of interpretation laid in Vienna Convention. If we look at it, the Article 31(1) says that treaty should be interpreted to give its ordinary meaning, duly taking into account the context in which words are told and the object and purpose for which the treaty is entered. Then Article 32 provides that there are a lot of, apart from the main provisions of the treaty itself, there are certain supplementary materials, preparatory work, etc. There are some other materials available. Those can also be taken into account if the interpretation that we did under Article 31(1) is ambiguous, or if it is not solving the purpose. Then Article 26 provides that every treaty is binding on both the parties, and whatever commitment has been given in the treaty must be performed by them in good faith. These are the main principles of interpretation of treaty provided in Vienna Law of Conventions. So if we were to apply these principles to the incident case, do we really think that the diplomats would have envisaged the scenario where a country with which they entered into treaty will become an OECD member at a later date? Would they have envisaged such a scenario? Would they have considered their objective and purpose for the treaty entered into with these parties, this Colombia, Lithuania, and other country? Whether they would have considered all these and then entered into this treaty? It's really a question mark. It's really difficult to answer this question whether they would have considered this and then considered a tax rate of 5%, or they would have not even envisaged this situation. If we say that they would have not even envisaged this situation, then in good faith, if they are to act in good faith, they might have come and say, we never envisaged this, let's negotiate this situation and try to find out a solution, or try to find out what is the tax implication on if such situation comes through. This particular principles of interpretation as per Vienna Convention has not been discussed in the judgment. We are not sure whether it was even argued or it was not. It was argued, but it is not documented in the judgment. We are not sure about it as such. However, it has not been dealt with in the judgment that is available to us. This these aspects could be considered by some other high court or before Supreme Court if these orders are appealed against in future when the same question of law comes up before them. Then one more point that has to be noted is in interpretation of treaty there are two principles of interpretation called as static approach and ambulatory approach. According to static approach, we should consider the conditions that were present on the date of signing the treaty. Any further any developments that happen in the future cannot be considered. Whereas ambulatory approach will provide flexibility to even consider the cases, even consider the developments that had happened after the treaty is entered into or after the particular law is framed. For example, if you see in the case of MasterCard, the permanent establishment was interpreted using ambulatory approach, and hence even a small card machine was considered to be a PE in that approach. It is an example for an ambulatory approach. Can we apply such ambulatory approach to treaties? Mumbai Tribunal, in the case of Reliance Jio Infocom in 2020, said no. If you were to apply the ambulatory approach, then the performance of the duties envisaged in the treaty by both the parties in good faith, which is given in Article 26 of Vienna Convention, will be violated, and hence ambulatory approach cannot be considered in the interpretation of treaties. Okay. So these are our observations on aspects that appear to have not been documented in the Delhi High Court judgment. Okay, now we have to think about what next also. What could be the way in which these could be resolved also. So if we were to think in that lines, there is a procedure called mutual agreement procedure (MAP) given in most of the treaties and even the OECD Model Convention of Treaties, which says the competent authorities appointed by each of the states, they can initiate talks, they can come up with mutual arrangements to resolve any difficulties or doubts in the interpretation or application of the DTA provisions of the DTA. So this could be one solution, to sit with the other treaty partner and say what exactly, to clarify what was the intent, how this to be interpreted and concluded upon. And they may come up with a notification saying this is what is the final resolution that was reached based on the map. Could be one. One more thing that could provide some intermediate for something is that the provisions of section 93. Section 93, 90 subsection 3, empowers the central government to assign meaning to any term in the treaty which is not defined either in the treaty or in the act. Because the treaty already provides certain definitions, and then it says that if there is no definition available in the treaty, then you can resort to local laws unless it is totally unless the context otherwise requires. So having said that, so if the definition is not available both in the treaty and in the act, then central government is empowered to issue a notification. Can central government issue a notification? Here is a big question mark. We are not very sure, because this is totally an interpretation of as to which is the relevant date for which has to be looked at. Whether can it be told as a term prima facie? We don't think so. Then also there is a controversy on the applicability of section 90 subsection 3 itself, because it is totally a unilateral act by the Indian tax authorities. It is not through a bilateral agreement with both the treaty partners. So there is controversies on whether 93 is valid itself. That is totally altogether. But still, maybe government can try its luck against this and see how it pans out. Yeah. Then, in light of this, now the CBDT has come up with circular 3/2022. We can just proceed to look at certain salient features of this circular. This circular acknowledges that each MFN class in the DTA have totally different formulation. There is no one size fit all for all the DTAs. It has each and every MFN class have different requirements given in respective protocols, respective MFN class itself. It acknowledges that. Then the circular goes on to say that it has the CBDT has received a lot of representation seeking clarity on whether the provisions of Slovenia, Colombia, Lithuania could be applied through MFN. So this is the context in which this circular has been issued, just to give clarity on applicability of this MFN. Then it goes on to say that the decree or official bulletin or publication issued by the treaty partners, say Netherlands, France, Swiss, and all, which they have issued a internal circular kind of thing there. They have said that it do not represent the shared understanding of both the treaty partners. It is totally unilateral interpretation by these partners. It goes on to say that it is not in accordance with the object and purpose with which the DTA was entered into. You would remember that we just discussed that the treaty should be interpreted taking into account the object and purpose in Vienna as per the principles of interpretation in Vienna Convention. Then, so CBD clarifies that these publications are not in accordance with that. This is a very important point. It could be considered by court in future. Then it goes on to clarify the position of the CBDT as such. CBDT says that its position is that the third country should be a member of OECD, both at the time of entering into the treaty and at the time when we are evaluating the tax implications. Only if the third country is member of OECD at both these things, then you can import it into MFN. Otherwise, it is not applicable to you. So far, I believe it's so good, and CBDT has really been just and it's okay. Till this, I think it provides clarity and all this. Till this aspect in the circular. Now we have to move on to the difficult aspects in the circular. Yeah, the circular says that all the MFN class require a separate notification under section 90 of the Act for it to operate. The reference, the circular quotes from the ruling of Supreme Court from Azadi Bachao Andolan. In the case of Azadi Bachao Andolan, Supreme Court was giving its judgment as to whether the beneficial provision contained in the treaty will override the local provisions of local income tax. In that context, Supreme Court had told that the moment a treaty is entered into and it is notified under section 91 as a DTA, as a treaty with the other partner, the moment the notification is done, then the provision of DTA will come into place, and whichever is the beneficial of these two could be applied. Now, CBDT resorts to this particular class, and CBDT goes on to say that based on this, even the MFN class would require notification under section 91. Only then it can operate. The issues that are there in such imposing such requirement under notification 91, let's go through those. One is that, as we discussed earlier also, different treaties have different languages employed in its protocol and in its MFN class. If we were to apply this requirement, then all those will go for a task. Let's just look at the examples, some of the examples where different languages have been employed. Say, for example, in India-Sweden treaty, it says the lower rate or lower scope, the moment India enters into an agreement with third country, which is a OECD country, then the same can be applied to India-Sweden. If you look at here, there is no additional conditions prescribed at all. It just says the moment you enter into treaty with somebody else, the same should be extended to me also, where it is beneficial, either through rate or through scope. It doesn't say it has to be notified or some other procedure has to be followed. It's very strict. So looking at this language, it is very clear that the operation of MFN should be automatic in this case. Let's move on to the next example. The language employed in the treaty between India and Swiss is very interesting. It gives where you enter into a treaty with a third country which is a OECD member for a lower rate of tax, then the same would be applicable for us also the moment the third country's treaty becomes into force. Whereas if you restrict the scope of taxing certain things, then India and Switzerland will sit and negotiate to provide that lower scope. So here also one can clearly understand that the lower rate is it is emphasized that the lower rate should be automatic, whereas if there is a reduction in scope, then that has to be negotiated. Then treaty may require some amendments and all that. Again, if we look at the definition, the language adopted in India-Finland treaty, it has been given that without any delay, these two parties should evaluate whether the conditions prescribed in such MFN is satisfied and a notification is issued. If you look at India Philippines, it says the moment you enter into a beneficial provision with third country, then both those countries can sit and review whether such same can be extended to Philippines as well. If you look at India Saudi Arabia treaty, it says that both the parties shall review such new agreement and resolve the issue. So we see that various again there's one more example of India UK treaty where it provides for both the countries to sit together. Here it specifically says that the provision of this should also reflect by the amended protocol. So when various treaties has given various languages and various requirements have been given, that how can we impose a same requirement under 91 to all these things as a blanket requirement? If we go on to say that, then it will become an inconsistency with all the provisions in all these treaties. Again, as we said, if you compare the local provision and provision in the treaty, provision in the treaty should override as long as it is beneficial. This is one major issue that is there. Second thing is that the already Delhi High Court divisional bench has ruled in Syria, India case that there is no requirement for a separate notification in case of India-France treaty, considering the language in India-France treaty. Again, this particular aspect given in the circular is totally contrary to such High Court ruling. Again, I repeat that this particular case, especially petition has been filed before Supreme Court against this particular High Court ruling. Then the circular started with a preamble to say that they are trying to clarify the applicability of the lower rate for dividend provided in Colombia, Lithuania, Slovenia treaties. But now imposing this particular condition here, actually this particular condition has a pervasive impact on all the MFN class and treaties. It will include all royalty, FTs, other income and all other provisions that have been given in the MFN as well. It is not just restricted to dividend. Whereas the circular which told that its intent was to clarify on dividend, but it is touching all other areas and creating chaos even in all other areas. Yeah. In this regard, we should also look at the in terms of in India, France, CBDT had already issued a notification in 2000, which actually gave a totally a different scope, different rate as compared to what should be ideally be given based on the plain reading of protocol, which we did some time back. The Kolkata ITAT, this is the observation of Kolkata High Court. I'm just reading it for your benefit. The perusal of the opposite notification gives a prima facie impression that it constitutes the central government's independent action to implement the understanding arrived at by virtue of the protocol clause in India-France DTAA. It is difficult to comprehend as to how central government can unilaterally amend in exercise of power under Section 90 of the Income Tax Act a bilateral agreement that DTAA is inherently is. So whatever provisions that is contained at present in the India-France DTA, it has been agreed by both the parties, India and France. How can such bilateral agreement be overridden through an unilateral notification issued under Section 90? This question has already been asked by the Kolkata Island in way back in the year 2002. So again, imposing the requirement of issuance of notification under Section 191 is again unilateral act. So these are the issues that we have with this imposition of requirement of notification under Section 90 of that. Now we move on to the next aspect in the circular, which is the circular goes on to say that in case of Slovenia and Lithuania, two rates have been prescribed. Only where the shareholder is a company and he is holding beneficially more than 10%, the 5% rate is extended. In other cases, the rate prescribed is 15%. The circular objects that you cannot just invoke only 5% rate and you cannot leave without invoking where the rate is 15%. Say, for example, in the Treaty of India, Netherlands, or India, France, or whichever, the rate prescribed in the treaty is 10%. The very objective of the MFN class is to import only the lower rate or the restricted scope. MFN is not written in such a fashion to import even a higher rate or unfavorable position from other treaties. That be the case, how can we say that you should import higher rate also from these treaties when you choose to invoke MFN clause? Again, it is not clear what exactly they try to convey in this particular clause. Yeah. So once these are the silent aspects that I had to discuss with regard to the CBDT circular. Now immediately within a week's time after the circular was issued, Pune ITAT had come up with its ruling in GRI Renewable Industries case, which addresses the major concern that we had with respect to the circular. The Pune ITAT specifically records its views, its observations on the circular. It contains specific reference to the circular. It says that the language of Section 90 subsection 1 has been overlooked. The Section 90 subsection 1 envisages issuance of notification only where a particular new treaty has been entered into with the country. It is not for the purpose of making a particular limb in the treaty effective or to make the MFN clause in the treaty effective. It is not. The notification is not required for individual limbs of the agreement or certain specific provision in the agreement as such. The requirement under Section 91 is only when a new treaty is entered with the other partner. This has been overlooked, and the circular is totally transgresses this requirement envisaged under Section 91. This is the observation of the ITAT ruling. Further, ITAT ruling also goes on to say that circular, as it has been already established in the past, and there is no doubt about it. The circulars issued by CBDT is only binding only on their subordinate tax authorities. That is the assessing officers and all. It is the assessee is not mandated to follow the circular. Even the tribunal or other appellate authorities are not mandated to follow the circular. So the ITAT again reiterates this and says that we are not bound by it, neither the assessees, so we need not consider the requirement of notification that has been envisaged in the circular. Even not ignoring the above, it says the circular has been issued in February 2022 or March 2022. It can never impose a new condition or a new disability to avail the provisions of the treaty which was done in the past. If at all somebody argues it is applicable, it has to be prospective effect for the transactions that are taking place after the date of circular only, then not for those what has happened before the date of the circular. This has also been clarified by the ITAT ruling. Yeah, so these are the aspects that I wanted to cover. I can just quickly summarize the discussions so far. Yeah. To just conclude, to present just as a concluding thoughts. We saw that in case of Syria, India, the Delhi High Court, the divisional bench of Delhi High Court has ruled that there is no separate notification is required for the operation of MSN class. However, we should bear it in mind that it is pending before Supreme Court now. Although the experts is of the view that a ruling favorable to the SC can be expected in this regard for the reasons that we discussed just a while. Then this Delhi High Court ruling in the case of Concentrix, Nestle, SA, Deccan Holding, and all these extending the treaty rate of 5%, where these countries became OECD member only after the date when the agreement DTA was entered into. This could also be challenged by the income tax authorities to the Supreme Court. So far, we are not aware of the SLP file in this regard, but the chances that should file is more, I believe. Then, in the case of the good thing about the circular is that it clarifies India's position with respect to application of these Slovenia, Lithuania, Colombia treaties into MFN of other treaties, which was not there before. So, in case of Honorable Delhi High Court, the Delhi High Court had considered the decree or official bulletin issued by the tax authorities of other treaty partners, whereas it was not sure what is India's position at that point of time. Now that India's position has been conveyed through this CBDT circular, just thinking that invoking the provision of mutual interpretation, same interpretation doesn't arise. Now that both the parties have come up with different interpretations, which is conflicting with each other, if the same question of law appears before same Delhi High Court or some other High Court, then they will have to give their independent interpretation, as we have the partners giving their conflicting interpretation in this matter. Then, as we just discussed, the requirement of notification under Section 19, as envisaged in the circular, is very far-fetched. It has a very wide implication even on royalty FTs and other matters, which is settled for the time being. Assuming this requirement is needed, now what will happen is all the cases where MFN has been invoked will become a matter of litigation at lower level of tax administration. The lower tax administration may not appreciate the Pune Act. It may say that the circular issued is binding on them, so they have to go with it. So the volume of litigations may go up if the controversy is not amicably resolved. Further, as we discussed, this requirement is not in line with the requirements given in each of the treaties with respect to invocation of MFN class. Each treaty have their own requirements, whereas this is totally in contravention of those requirements. So, what could be the solution in arriving at a consensus or arriving at a certainty on this matter? Is one of the things, as we discussed, mutual agreement procedure. Not that only department can initiate, even the assessee can initiate it. The assessee who has earned dividend income and who is not clear as to the applicable tax rate for them, they can also invoke the requirement under map, and they can say, please, both the countries, you please sit together, resolve this and come back to us with the further certainty. This is probably this appears could be a possible solution to bring this to a conclusion. But again, question is, based on our past experience and all that, map procedure is very time consuming procedures. When we will have certainty through this route is really a question. Yeah, this marks the end of the thoughts that I wanted to share. I'm open for any questions that you may have.
Thank you, Mr. Sathyamurthy. Thank you very much. So I think we come back to the classical debate of whether every time the legislature takes a view, and here we have a slightly bigger issue where you have country to country protocol, and I mean, obviously double tax treaties, when they are negotiated, I'm sure that the views of the bureaucrats and the finance ministries and the tax teams are taken for sure. I don't think these are done purely by politicians, although of course it is a diplomatic negotiation at the end of it. So now we have a situation where not just what the legislature does, not just what the judiciary does after due deliberation, and not just what country to country protocol does after due deliberation, we hope. The legislature is still kind of going to step in and say, we will rule the roost. And I think this is increasingly so. If you look at the last finance bill as well in the same context, we are seeing that increasingly you have a situation where the legislature is coming up and saying that if courts take a view which is against which is pro assessee or which is against the intent of the revenue, all it takes for us to do is to make a legislative amendment. And while we may not be able to do a lot of things retrospectively, at least so far as prospective is concerned, we are going to plug a lot of this. I think, of course, this time what has happened is we have bitten more than what we can chew, because in the past when this happened, it was a tussle between the Indian judiciary and the Indian legislature. And we've seen who's kind of won over a period of time. But now you have a situation where you're going to invoke international protocols and you're going to invoke a country to country situation. So obviously, I mean, in a situation like this, if there is a resident of a foreign country who is large and strong enough, I'm sure they are not going to take this lying down and say that, okay, so if India came out with a circular which restricts an MFN and which says that, okay, you'll pay a tax of 10% on dividend or 20% on dividend and we won't reduce it to a 5%. I don't see the international community kind of keeping quiet and bowing down to the vagaries of what the Indian bureaucracy thinks or what the Indian legislature thinks. So I think this is going to be an interesting debate. It's going to be interesting to see how this whole thing plays out. I don't see the CBDT circular being withdrawn, of course, as always. At the same time, I thought this was probably the fastest action taken by the judiciary on a circular like this. I wait to see how soon a High Court or a Supreme Court, at least a High Court, will reverse the view of Pune Tribunal. But I thought the judgment was a fairly detailed judgment as well. I mean, it's covered a lot of ground, and I think we have interesting times ahead.
Sure, sir, sure. Yeah, as you said,
Any
your comment is very valid that legislature is doing a bit far-fetched activities nowadays. Probably it's a matter of concern which should be addressed by them at the earliest. Probably the way they look at it, sir, they are always biased pro revenue. Probably they should have an independent mindset to evaluate both sides and then take a decision or something like that.
So actually, that is precisely why we have this arrangement which says that the legislature, obviously in their best intent, is supposed to look at revenue collection and is supposed to look at administration of revenue. So that is a one-point agenda so far as they are concerned. The reason you have a judiciary is that there is somebody who doesn't have the same vested interest which the legislature has, and who will therefore in an independent manner consider the view of the assessee, consider the view of the revenue, and then take an independent call, which could at sometimes be in favor of one and sometimes in favor of the other. So the whole idea of an independent judiciary, if you are able to have one, is essentially to look at things in a little more dispassionate manner, saying there is always going to be batting of this kind where the CBDT will try to and the legislature both will try and legislate what favors them. Assessees will obviously take views which favor them, and somebody which is a neutral judge will have to step in and say, okay, let's hear both out and look at precedents and take a call.
Yeah. One concern here is that the time consummated for a matter to get a resolution through the route of judiciary is too long, and more often than not, the associate feel like let the matter become certain in whichever way, whether it is favorable or unfavorable, and let's not keep on dragging this for a very long time.
True.
Probably
Any
some
questions
reforms
from
are
anyone
required.
else? Any questions from anyone else? Sorry, sir, you were saying something. I'm sorry. You
No,
were
I'm
saying
saying
something.
probably some reforms are required in appellate authorities or judiciaries to ensure that justice is delayed in time. Justice is delivered in time.
Yeah. That's true. That's true. Okay, so I must take this opportunity once again to thank you, Mr. Sathyamurthy. Thank you very much for volunteering and presenting on an interesting topic today. Of course, this is the curtain call for the study group for the year, and we look forward to, let's see how it plays out in the future. But thank you very much, sir, and wish you all the very, very best. Yeah.
Thank you very much for the opportunity granted to me to to collate all the literature, judiciary, and share my views on this topic. Personal thanks to you for personal interest taken in going through the presentation in advance and sharing your inputs as well. On overall basis, I share my thanks to the conveners of the group and WERC as well.
Yeah, sorry, we didn't have a large enough audience this time, and I really don't know why. But the presentation was really, really detailed, and I think for the people who were there, huge takeaways, and I think it's something that's going to be really useful to everyone. So thank you very
Definitely.
much. Have a good evening and a good weekend. All the best to you. Take care.
Thank you very much,
Bye.
sir.
Bye,
Bye.
sir. Bye. Bye.